What are some of the copyright laws in the United States? The most specific law is U.S. Code 17, also known as the Copyright Law of the United States. This law outlines everything from exclusive rights, transfers, registration, duration, and fair use. For educators, the fair use clause is most important. This tells us that many properties can be used in the classroom so long as they are for nonprofit educational use. It is important to note that there are still some works that are not allowed to be used. In addition, ownership of the work must still be given. In the age of the internet, more copyright protection was required. The Digital Millennium Copyright Act works to protect technology and services that may otherwise be easy to reproduce. There have been many court cases outlining protections, such as Viacom versus Google. Today, the results of these cases have led to different types of licenses for digital works. In general, the same rules apply for educators to use digital resources as it does for physical ones. The U.S. Constitution even has a clause on copyright, although it is far less extensive than the previously listed laws. Article 1, Section 8, Clause 8, as well as the First Amendment, offer basic protections to authors and inventors. The primary law for copyrights in the United States is the Copyright Act of 1976. This act outlines several of the key components from previous laws, but it codifies the specifics of the Fair Use Clause. In general, the law outlines 4 factors to consider when using a copyrighted work under fair use: the purpose and the character of the use, whether it's commercial, educational, reproductive; the nature of the copyrighted work, whether it's fiction, factual, or the degree of creativity; the amount of the copyrighted work being used, whether it's a small single poem or one chapter of a book; and the effect that the use has on the market for the original work.